law. This is an important aspect of international law. It has to do with effectiveness. It has to do with the question of participation of national organs, domestic decision making, and so on. There will be several analyses in this program, covered by the program. There may be different points of departure, but there will be a good reasoning behind the conclusions we are going to achieve. So thank you very much for the initiative. And I would like to introduce the participants from the Chilean side. We have Professor Sebastián López, who is a member of the Catholic University of Chile. Professor Ximena Fuentes, currently ambassador, as you said, who is also president of the Chilean Society of International Law. And then to replace Mrs. and Professor Carolina Valdivia, who excused herself for personal reasons, we have the pleasure to introduce Professor Paula Cortés from the University of Chile, too, who is actively involved in the Department of International Law of our university. So thank you very much. And with this, I give you the floor.
Well, thank you very much, Maria Teresa. I share the sense of great pleasure, mucha alegría en el mismo tiempo, that we managed to put together this event testifying to the excellent and special relations between Italian and Chilean international lawyers within the framework of the ILA, and the choice of today's topic also witnesses to the importance of the mission of the International Law Association in promoting international law, not just amongst those who study and research international law, but also among those who practice law, so that there is further knowledge of international law. Because as the British say, I know what I like and I like what you know. The more you know international law, the more you apply and comply with it. The less you do know, the less you apply it. And if I may take a passage from Rosalind Higgins, today we will be discussing the relations between international law and domestic law on different levels. And in discussing in her seminal general course at the Hague Academy, after addressing the big issue of monism and dualism, she makes a very pragmatic consideration that I want to share with you all, which I think helps introducing our discussions this afternoon. And I quote, "Related to this great jurisprudential debate over monism and dualism is a further reality not to be found in the textbooks, but which must be mentioned. This is the reality of legal culture. In some jurisdictions, international law will be treated as a familiar topic, one that both the judge and the counsel before him will expect to deal with on a routine basis. Of course, this attitude is more to be expected in systems accepting the monistic view. But I speak of very practical matters. The judge and lawyers in his court will have studied international law and will be familiar with it, as they are familiar with any other branches of the law. But there is another culture that exists in which it is possible to become a practicing lawyer without having studied international law, and indeed to become a judge knowing no international law. Psychologically, that disposes both counsel and judge to treat international law as some exotic branch of the law, to be avoided if at all possible, and to be looked upon as if it is unreal, of no practical application in the real world." End of quotation. And I'm afraid this is increasingly widespread a phenomenon, which I think that all of us involved in today's exercise will be trying to make up for. And now, thank you for bearing with my digression, to the Italian participants. The first speaker in the first session will be Professor Fulvio Maria Palombino. He's a full professor of international law at the University of Naples, and he teaches in other universities. He's a good friend. We work together with the Ministry of Foreign Affairs. We are together in a legal team in a case pending before the International Court of Justice, and I'm benefiting from his skills and knowledge, particularly in the field where we are going to discuss and put our thoughts this afternoon. Next is Riccardo Pavoni from the University of Siena, also very good friend, full professor there, general editor of the Italian Yearbook of International Law, a member, sorry about this. He also is a co-director at Tulane Siena Institute for International Law, Cultural Heritage and Arts, a member of the European Society of International Law and of the Italian Society of International Law and European Union Law. Lorenza Mola, Associate Professor of International Law at the University of Turin. She also combines her scholarly background with a practical side to her professional career. She has gained professional experience at the Italian mission to the WTO, at the European Commission's General Division on Trade, Investment Unit, and an external consultant for the Italian Development Cooperation, amongst many other merits. And with that presentation, Donato, please help me if I have forgotten anyone. And if I haven't, I would pass the floor on to you, Maria Teresa.
Professor, I think it's just worth mentioning that the webinar is co-organized, of course, by ILA Chile together with ILA Italy and with the collaboration of the Sociedad Chilena de Derecho Internacional and the Italian Society of International Law, specifically the Interest Group on Domestic Law and International Law, which is co-chaired by Professor Pavoni, which is now a speaker in today's meeting. And I give you back the floor.
Well, thank you very much, Donato. That was absolutely essential. That is a very good integration and very important that we, the ILA branches, collaborate with our international law national societies. So, Maria Teresa.
Thank you very much, Attila, and welcome everybody. I see new names joining our group. Well, we go to the first panel. It will deal with the competence to conclude treaties under the constitutional law of each of our countries. So I think I will give the floor to Professor Sebastián López to speak first, and then we'll have Fulvio Palombino from the University of Naples. Sebastián, you have the floor.
Thank you, Maria Teresa. I'm going to share now my presentation. Please tell me if I am successful. Can you see it?
Yes.
Well, first of all, I would like to thank the Chilean branch of the International Law Association, as well as the Italian branch, for this invitation to this very interesting webinar, particularly to Professors Maria Teresa Infante and Professor Attila Tanzi, who have been so nice to present us. And the topic that I am going to be talking about this morning, at least morning in Chile, is the competence to conclude treaties under Chilean constitutional law. I understand that other topics on the relationship between international law and domestic law are going to be addressed later, so I'm going to stick to that. So, first of all, well, normally the relationship between international law and domestic law can be found in the different constitutions of the states that comprise the international society. That is the general rule, even though there are some constitutions that do not refer to international law. In the case of the Chilean constitution, currently in force, we don't have a systematic normative framework for this relationship, but we only have scattered constitutional provisions that refer to different aspects of international law, when governing different situations. For instance, we have there in the slide article, as they appear in the Constitution, Article 5, Paragraph 2, which relates to the exercise of sovereignty, and it was introduced in the important constitutional reform of 1989. We also have Article 32, number 15, referring to the functions, the powers, if you prefer, of the President of the Republic. And this is a more traditional provision that you can find in the original wording of the 1920 Constitution. Normally, they go back to the 1925 Constitution and sometimes to the 1833 Constitution of Chile. We also have another important provision in Article 54, number 1, sorry, I missed the number there, which has part of the original wording of the 1920 Constitution and some very interesting inclusions made by the 2005 constitutional reform. And finally, we have the last provision, which would be Article 93 on the powers of the Constitutional Court, particularly number 1, number 3, and number 6, which refer to the control of constitutionality, which, as we're going to see, can be ex ante or it can be ex post. Those are the provisions, that's it, not more. So because there's no systematic approach, it has been the Chilean doctrine, the Chilean case law, obviously, that has taken the task of specifying the solution to these problems. What can we say about treaties in brief, obviously? Well, normally the relationship between international law and domestic law refers to two big issues, which is the incorporation and the rank. As to the incorporation, as we're going to see, most treaties, the general rule is that in Chile, they require parliamentary approval. And even if they don't have this approval, they will be adopted in Chilean law. We're going to see how. As to the rank, which I understand is going to be addressed after me, well, I can tell you what the Constitutional Court says. This is not a Pacific issue in Chile. Our court considers that treaties have a supralegal rank, but an infraconstitutional one. That is not, for instance, the view of the Supreme Court in many of its judgments and the doctrine that consider sometimes, in the case of human rights treaties, that they have an equivalent rank because of Article 5, Paragraph 2. Now, this approach by the Constitutional Court poses certain problems, obviously. First of all, the risk of engaging the international responsibility of the state of Chile, particularly considering that our state is a member of the Inter-American human rights system, right? And there we have this very important notion of the control of conventionality, which has been developed by the case law of the Inter-American Court. So finding a way to pull all the pieces of this puzzle together can be tricky. But let's go to what we're going to discuss today, which is the conclusion and obviously the incorporation. So let's see who are the main actors in this drama. So first of all, we have the President of the Republic, which is the one in charge of the negotiation and conclusion of treaties. We're going to read the corresponding provisions. So he's always going to be involved. But we also have the National Congress, which is in charge of the treaty approval, as you can see in the slide, usually because there's a couple of exceptions called the executive agreements and simplified agreements. And finally, as another actor, we have the Constitutional Court, and this will appear eventually in the case it exercises an ex ante or an ex post control of constitutionality. So let's start by looking at the provisions, which I think are going to repeat themselves in the following presentations. First of all, we have Article 32, which states that, and I quote, "The special powers of the President of the Republic are, number 15, to conduct political relations with foreign powers and international organizations and conduct negotiations, conclude, sign, and ratify the treaties that it deems appropriate to the interest of the country, which shall be submitted for congressional approval as prescribed in Article 54, number 1. As you can see, the source for this translation is the Constitute Project. I changed a couple of words that I didn't like, but normally you can find that translation there. So that's for Article 32, number 15. We're going to get back to the interpretation of this provision. but we also have to refer to this other one, Article 54, which, and I quote, says the powers of the Congress are, number one, to approve or reject international treaties presented by the President of the Republic prior to the ratification. The approval of a treaty will require in each house the quorum that corresponds in accordance with Article 66. And it says that shall be submitted as appropriate to the formalities of law. Finally, the President of the Republic shall inform the Congress about the content and scope of the treaty, as well as the reservations that he pretends to confirm or formulate to it. So let's see how this last provision has been interpreted. First of all, like in other constitutions, treaties, the negotiation and conclusion of treaties are left to the executive power. Being a manifestation of the political will of the state, one of the manifestations of the political state, it makes sense because it is left to the most dynamic of these powers. In our case, it is embodied in the President of the Republic, as we said. And if you might remember, the wording is an old one because it says to conduct political relations with foreign powers. So it assumes that we are a power, which is a nice thing. But it is an old way of saying that we are another state, and obviously international organizations. So it is the President of the Republic who's going to be basically in charge of the conclusion of the treaty. But as to the incorporation, the last part of this provision says that they shall be submitted for congressional approval as prescribed in Article 54, number 1. So we have a renvoi basically at the end of this provision, which leads to this one that we're going to discuss. This first paragraph is, in my opinion, one of the most interesting ones because it adds a number of different rules that have been interpreted by the Constitutional Court, for instance. So first of all, it is for the Congress to generally approve or reject the treaties that are presented to the President prior to their ratification. As I said, this is usually the case because later on, in a different paragraph of this provision, we're going to find the two exceptions. And as it says here, this approval is going to require different quora depending on the norms of the treaty. So in the case of Chile, and we have to go to Article 66, which basically refers to the different quora of the different types of law that we have in Chile. We have in Chile at the moment interpretative laws, organic constitutional laws, laws of qualified quorum, and simple laws. And the quorum differs. Interpretative laws are 4/7 of the members of the Chamber of Deputies and the Senate in exercise. And as to, if I'm not wrong, organic constitutional laws and laws of qualified quorum and absolute majority of those members. Simple laws, on the other hand, is just the majority of the members present at the moment in the House. Okay, so normally the Constitution says which are the matters that are going to be governed by the different types of laws. So what we have to do is take a look at the treaty, look at its norms, and see if the matters, the corresponding matters there, refer to one of these different types of laws. Then we have to apply different quora. This used to be more important, but lately in one of our last reforms, this quora had been reduced. So it's not much of an issue these days, I will have to say. But there's this phrase here which says that treaties have to be submitted as appropriate to the formalities of a law, which is more interesting, as we're going to see, because it refers to the adoption. By the way, it is both houses of Congress, the Chamber of Deputies and the Senate, that must express their opinion. They have to approve or reject. And according to the Constitutional Court, because treaties are not law proper, they're not equivalent to a statute, they have a different legal nature, the houses of Congress have to do this in one voting, and they have to approve or reject the treaty as a whole. They cannot introduce modifications to this, okay? As I was saying, we have this last phrase here saying that treaties shall be submitted as appropriate to the formalities of a law. Originally, the 1980 Constitution said that they shall be submitted to the formalities of a law. And in 2005, in the constitutional reform of that year, the phrase as appropriate was added. And this is important because in Chile, treaties enter into force in the same form that that laws enter into force in Chile. So we have to go to our Civil Code, Articles 6 and 7. There has to be a decree that has to be enacted by the president and then published in the official gazette, in the Diario Oficial, as it is called in Chile. And that is the way they enter into force. Now, in principle, we might think that treaties are going to be transformed into domestic law because of this procedure. But because of this phrase, and as the way the Constitutional Court has construed it, treaties do not lose their legal character, their international legal character, meaning that they continue to be an international agreement. And this is important because the date of the entry into force of the treaty will depend on what the treaty says. The rules of interpretation are going to be those of the Vienna Convention on the Law of Treaties, not the rules of the Civil Code, which are normally applied in Chile. And it also has some bearing in the internal hierarchy of treaties, okay? What else can we say here? Well, the interpretation, as we were saying, treaties require parliamentary approval. That would be the general rule. Our doctrine has said this is an enabling formality, formalidad habilitante, in the sense that without it, the president cannot issue the subsequent administrative measure of ratification. Now, the quorum, as I already explained, has to be the highest applicable depending on the norms of the treaty. They have to be voted as a whole in the Chamber of Deputies and the Senate. And finally, they are adopted. They are not transformed. They are adopted. They continue to be treaties by this decree enacted and published in the official gazette. But Article 54 has more interesting things for us. So if we go to paragraph 4, we can see that, sorry for there is a typo there. The agreement that the president concludes to comply with the treaty in force will not require new congressional approval unless they concern matters of law. And then the treaties concluded by the President of the Republic in exercise of his regulatory power will not require congressional approval. These are the two exceptions to the parliamentary approval. First of all, executive agreements, a notion that comes back all the way from the 1776 US Constitution. This was introduced by the 1980 Constitution, this idea that there's going to be some treaties to comply with treaties in force, unless they concern matters of law, in which case they will need congressional approval. The other modification was introduced in 2005, and it refers to what has been called simplified agreements, and it refers to those treaties that the president conclude in the exercise of its regulatory power. So that would be the two exceptions to the parliamentary approval. There's something else in Article 54 which is important, quite important in my opinion, which is paragraph 5. And this paragraph says, and I quote, "The provisions of a treaty may only be repealed, amended, or suspended in the manner provided in the treaty themselves, or in accordance with the general rules of international law," end quote. This provision is taken from Article 96, paragraph 1 of the 1978 Spanish Constitution, and it was introduced in 2005. It is an important rule because it helps us to figure out what the legal rank of treaties are. And also, it, as we're going to see, establishes the principle of lex superior for certain purposes, for the purposes of termination, suspension, and modification of treaties. So this little paragraph here, paragraph 5, is very useful these days for interpreting the position of treaties in Chile. Finally, we have a couple of paragraphs in 54, which is a long provision, so you're just seeing excerpts of that, paragraphs 6 and 7. And these are less important, but I think it was worth mentioning. The first one says, paragraph 6, I quote, "It corresponds to the President of the Republic the exclusive power to denounce a treaty or withdraw from it, for which he shall ask for the opinion of both branches of the Congress in the case that the treaties have been approved by it." So it is for the president to terminate the treaty. It will have to ask the opinion, only the advice of the Congress in case this treaty has been approved. And there's a final provision here in paragraph 7 of Article 54, number 1, saying that in the case of the denunciation or withdrawal from a treaty that was approved by Congress, the President of the Republic shall inform of that to it within 15 days of effecting the denunciation or withdrawal. So there's another duty of just informing the Congress in the case of termination of treaties. So the interpretation of all these paragraphs. As we were mentioning, there's no need of parliamentary approval for executive agreements, obviously, unless they concern matters of law, and simplified agreements that can be found in paragraph 4 that we just read. And then we have the important paragraph 5, establishing the principle of lex superior for the purposes of termination, suspension, and modification of treaties. And finally, referring to the termination of treaties, it is going to be the President of the Republic who's going to have the power for that, and only will have to ask for the advice of the National Congress and inform it in case that treaty has already been approved by Congress. And moving on to the last provision, which would be Article 93, referring to the powers of the Constitutional Court, we have other important issues emerging from these rules. The first one is number 1 of this provision, which was introduced in the Constitution in 2005. And it says, I quote, "The powers of the Constitutional Court are 1, to exercise the control of constitutionality of the norms of the treaty which are related to matters belonging to constitutional organic laws prior their promulgation, or enactment, if you prefer." This was introduced as an ex ante control of constitutionality, also called preventive in the case in Chilean doctrine. So it is for the Constitutional Court to exercise this control only when the norms of a treaty refer to matters of constitutional organic laws that, as we saw, are mentioned within the different provisions of the Constitution. This is going to be obviously eventual. This is compulsory in the sense that the Constitutional Court has to exercise this control if it finds that the norm refers to a matter of constitutional organic law, but only if that situation emerges or appears, okay? So that would be the first one. Now we have another control of constitutionality. As Article 93 says, the powers of the Constitutional Court are 3, to resolve questions of constitutionality that appear during the processing of the treaties subject to congressional approval. This already existed in our Constitution in force, and it refers to the questions of constitutionality that emerge in the process of approving or rejecting the treaty. Who can ask this? The President of the Republic, the President of the Senate, the President of the Chamber of Deputies, 1/4 of its members, and it has only, it can be done not after 5 days of the corresponding approval. This is also eventual. It will only appear if there's a question of constitutionality, but it is optional, not compulsory like the first one, in the sense that these organs can ask for it if they consider that there's an issue of constitutionality there, and if not, it's not going to appear. Now, these two, we're going to see controls ex ante, do not pose problems in the sense that they can be considered to be a way of fulfilling the duty, the general duty, of bringing municipal law into conformity with the international commitments of the state of Chile. So at least in my opinion, I have no issues with ex ante controls of constitutionality. I think they are actually a good idea. I am not of that opinion referring to this control of constitutionality, which is ex post. And I read the Constitution again. The powers of the Constitutional Court are 6, to resolve by the majority of its active members the inapplicability of a legal rule whose application in any procedure to be followed before a regular or special court is contrary to the Constitution. This is called in Chilean doctrine the action of inapplicability, and it can be filed by the intervening party in a contentious or not contentious process by the corresponding judge. And the problem here is that it is also eventual, because it can be filed or it can be decided by the judge. But the thing is that here we have a treaty which is already in force. So even though this declaration of inapplicability is going to have an effect only in that process, it can present certain problems in the sense that eventually it can lead to the breach of an international obligation established in a treaty or even in an international custom. So it has been debated. I don't think it's a good idea to have this interpretation. It all has to do with the way we construe the phrase legal rule, precepto legal, in the original Spanish version. So some authors consider that legal rule only refers to internal laws, and some others say that actually they include treaties. If they include treaties, obviously we might have this ex post control of constitutionality. Interpretation then of all these different provisions on the Constitutional Court. First of all, as you can see, if you might remember, the ex ante control, which is compulsory in number 1 for treaties related to matters of constitutional organic law. And then in the case of number 3 is ex ante again, but it's optional and refers to questions of constitutionality that appear during the approval of treaties. Here, the most polemic one, if you want, debatable, the ex post control of constitutionality, which is again optional. It might happen or not, and refers to the inapplicability of a legal rule which is contrary to the Constitution. Why is it a problem? As I was saying, because it can contravene Article 27 of the Vienna Convention on the Law of Treaties, which, as we all know, says that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. So this poses certain questions. Finally, conclusion, because I'm going to leave some time if we want to discuss any of these provisions. The competence to conclude a treaty, very simple in Chile, it is in the hands of the President of the Republic. But the National Congress is also an important actor. It participates in the comparison of these treaties in Chile. And as we're saying, as a general rule, because there are a couple of exceptions in which there are some agreements that are not going to require this approval. And finally, the Constitutional Court might exceptionally also appear in the case it exercises the control of constitutionality, which can be ex ante, as we saw, or it can be ex post, according to some part of our doctrine. So I'm going to leave it there. I hope it was of your interest, and I'm open to discuss the subject if you feel like. Thank you.
Thank you very much, Sebastián. Yes, Attila, would you like to introduce Professor? Yes.
Thank you very much. I imagine there will be plenty of questions to Sebastián, but they will come after. We hear the Italian version of the issue on competence to conclude treaties under the Italian constitutional law. And without further ado, I give the floor to Fulvio Palombino. You have the floor, Fulvio.
Can you hear me? Just a moment.
Yes, very well.
Sorry. Okay, so thank you very much. Thank you very much to Professor Infante, Professor Tanzi for inviting me and involving me in such a seminar. And of course, thanks a lot also to ISIL Italy and Chile. The subject I'm going to talk about over the next few minutes, as you already know, is the competence to conclude treaties under the constitutional law of Italy. And of course, also in my case, I will start with the constitutional provisions dealing with the matter, i.e. Article 80, Article 87, Paragraph 8, and Article 89. A joint reading of these provisions allows me to state that, first of all, the Parliament shall authorize by law the ratification of such international treaties as have a political nature, require arbitration or a legal settlement, entail change of borders, spending on new legislation. Secondly, that the President of the Republic will ratify these treaties. And thirdly, that's something which is not written in our Constitution, the last word as regards the entry into force of a treaty is always up to the government, which is enabled to decide whether or not to deposit or exchange the ratification. In a few words, the picture depicted by the Constitution tells us that the conclusion of an international treaty always implies the involvement of three state organs, i.e. the Parliament, the President of the Republic, and the government. Quite the opposite, the Constitution says absolutely nothing about the possibility of resorting to alternative procedures for concluding agreements. Notwithstanding this, on multiple occasions, Italy has entered into the so-called simplified agreements, a category which has been relied on by Sebastián, i.e. those agreements that bind the state internationally by the sole act of the government signatures without the intervention of the other competent constitutional bodies. So, in other words, on the one hand, we have a solemn or ordinary procedure which involves three state organs, the Parliament, the President of the Republic, and the government. On the other hand, we have a simplified procedure according to which an international treaty may be concluded by the government only, so through the signature of the government. As a consequence, that's a huge problem in Italy. The question arises as to whether these agreements, the simplified agreements, may be regarded as compatible with the Italian Constitution. Well, sorry, okay. We have two views in this regard. According to the minority view, that's an opinion which has been taken by a small group of constitutional lawyers. Simplified agreements would always be incompatible with the Italian Constitution, and the reason would rest on the fact that, according to these authors, departing from the Constitution would imply compromising the balance of powers provided therein. Indeed, this thesis is not convincing at all for a series of reasons, but first of all for normative reasons. This opinion clearly clashes with Article 1 of a law of 1984, that's the law concerning the publication of normative acts in Italy. According to this article, all agreements to which the Republic commits itself in international relations, including those in simplified form, must be published in the official Gazette. So in other words, the Italian national legal system is, of course, open to the simplified procedure. The question is another one. First of all, what's the legal basis of these agreements in Italy? And secondly, whether there is any kind of limitation ratione materia in terms of content as regards the matters which may be covered by a simplified agreement concluded by the government. Also in this case, so as you can see, there is really a huge debate in Italy. Also from this point of view, so as regards that part of the doctrine trying to provide constitutional coverage to simplified agreements, also from this point of view, there are a series of theses. Opinion number one, the power to conclude simplified agreements would come from the president implicitly delegating this authority to the government. This thesis is not convincing at all, to say the least, and the reason is not hard to grasp. The Constitution, as you can read in the PowerPoint presentation, our Constitution does not provide for the delegability of presidential functions. Opinion, thesis number two, simplified agreements, according to this opinion, would be admissible because, as a matter of principle, simplified agreements are limited to technical matters within the competence of individual ministers. Also, this thesis is not convincing. Any side agreement commits the entire government to implement that agreement and the parliament to enact any necessary norms for its practical application. The third thesis, the third opinion, is of course the most convincing one. According to this group of authors, the government's power to conclude simplified agreements would derive from a customary norm. Still, the nature, international or domestic, and especially the extent of this norm remains highly debated. According to some authors, this norm would be international in nature. This opinion is not convincing. As we know, as international lawyer, general international law tends to promote the freedom of forms in the conclusion of agreements, leaving the choice and the burden of enforcing them to individual states. So, in other words, affirming the existence of an international custom enabling the government to depart from what the Constitution states makes no sense. The other opinion is, of course, the most convincing. I'm talking about the opinion according to which the custom we are talking about would be a constitutional custom. But the problem now, of course, as I anticipated, is the content of this custom. We have to establish at the end of the day which kind of matters may be covered by a simplified agreement concluded by the government. The prevailing view, according to most authors, there are several authors affirming and let's say sustaining this kind of opinion, the government would have the power to conclude simplified agreements only for those categories of agreements that fall outside Article 80 of the Constitution. So this means, as a consequence, that where the government exceeds the limits of Article 80, the agreement could be subject to the invalidity clause under Article 46 of the Vienna Convention on the Law of the Treaties. why this opinion is not convincing? For a series of reasons. But the first reason and the main reason explaining why this opinion is not convincing at all is a practical reason. It's a very practical reason. So if we go back to the text of Article 80 of the Italian Constitution, so the idea of the drafters of the Italian Constitution was that to cover all possible agreements. And that's the reason why Article 80 speaks of treaties having a political nature, requiring arbitration or a legal settlement, entailing change of borders, depending on your legislation. Now, the problem is quite clear. If we look at the content of Article 80 and we concentrate, for example, on the first category of treaties relied on by Article 80, so treaties having a political nature, this category has been inserted into Article 80 of the Constitution precisely with the perspective of covering any possible international treaty. And of course, I agree with this kind of opinion in the sense that I think it's really very difficult to identify international treaties which do not have a political nature. And that's the reason why, over the years, so that's the point, the government has concluded agreements in simplified form within every category indicated in Article 80 of the Constitution. So it's a quite paradoxical situation. Article 8 provides for a solemn procedure to be followed, but the government, and we are talking about a 70 years long practice, has always concluded agreements in simplified form within every category indicated in Article 80 of the Constitution. And what's, the circumstance to be taken into account in this regard is that the constitutionally competent bodies, so the other bodies, as a matter of principle, involved in the procedure envisaged by Article 80, i.e. the President of the Republic and the Parliament, almost always have given the acquiescence. Now, in which way, we can interpret this practice? This practice, from my point of view, renders plausible the formation of a custom that modifies the Constitution, i.e. a custom contra Constitutionem, whereby the government would be authorized to conclude agreements in simplified form without any limit ratione materiae, deciding on a case-by-case basis whether to submit the agreement for parliamentary authorization. In other words, the behavior of the constitutional bodies, I'm talking about the Parliament and the President of the Republic, is allowed for the realization of both the objective and the subjective element of this customary norm, particularly since repeated non-contestation over time amounts to consent. In other words, a customary norm has developed in derogation of Article 80 of the Constitution. Now, this may sounds a bit strange, curious. We are international lawyers, and the concept of customary law is something which is really part of our DNA. Of course, it's not the same if we look at the subject through the lens of a national legal order like Italy, where the Constitution is rigid and a constitutional change is possible only as a result of a proceeding of constitutional revision, which is a very complex procedure provided for in Article 138 of the Constitution. But indeed, constitutional customs exist in Italy, and in a way they reflect what famous constitutional lawyer Costantino Mortati called Costituzione materiale, as opposed to Costituzione formale. So the living constitution as opposed to the written constitution. And what is important to stress in this regard is that the Constitutional Court itself, over the years, has admitted the existence of constitutional customs. One example may be found in judgment number 129 of 1981. In this case, the Constitutional Court affirmed the existence of a customary norm derogated from Article 103 of the Constitution, a complex provision dealing also with military tribunals, despite the Constitution, as I already said, should only be amended through the procedure provided for in Article 138 of the Constitution. What I'm saying is, of course, proved by, as I said, a huge practice. So regarding any kind of treaty provided for in Article 80 of the Constitution, we have a series of cases which could be relied on. I will not go into further detail because of the time constraints. But what I would like to say in order to conclude that this whole practice, also to quote a passage of a very famous lawyer, Tommaso Perassi, even though I will quote this passage in a different fashion, all this practice is, of course, a precedent demonstrating, proving the existence of a constitutional custom which enables the government to conclude simplified agreements in any matters covered by Article 18 of the Italian Constitution. That's a precedent from my point of view and not an oversight. Thank you very much for your attention.
Thank you very much, Professor. It has been a very, very instructive presentation and plenty of insights. Do we take 2 questions or 2 observations, Attila, Professor?
I think we can keep we can open the floor.
We can open the floor and take two short questions.
Yes, yes.
Who would like to raise an issue?
If there are no requests, I would like to...
No requests?
Maybe while the request will be in the pipeline, I would like to ask a general question to Sebastián, actually, because I'm less familiar with the Chilean constitution than the Italian constitution, of course. And from my understanding of your reading of the combined provisions 32, Article 32 and Article 54, I took it, but please do correct me if I understood wrongly, that it seems that, as if at least, the president has sort of full freedom to conclude by signature or ratification. Now, conclusion, signature, ratification, an international treaty. There are obligations under Article 54, whereby the procedure requires the Congress to approve, and if it doesn't approve, it rejects. But I understood from your words that once the president has signed or ratified or concluded, as you wish, an international treaty, whether the parliament has approved or rejected, it is a matter for the validity of the treaty just for purposes of domestic law. And the treaty is to be considered as valid as a source of international obligations for the government of Chile. Is my reading correct of your words, or my understanding? And if that is true, would then be there a constitutional procedure whereby the Congress could try and resort to whatever procedure for the government to invoke the invalidity of the treaty promptly under Article 46 of the Vienna Convention, the law of treaties?
Thank you for your...
Or is the whole constitutional system bound by the decision of the president to conclude a treaty despite the Congress being against it?
Okay, no problem. The power to conclude a treaty is in the hands of the President of the Republic, mainly. The Congress has to approve most treaties, and because it has been considered an enabling formality, the President cannot move forward to the ratification of the treaty if it has not the approval of the Congress. So both interact in this scenario. Once the Congress has given the approval, the President can later ratify. If the Congress rejects the treaty, then the President should not ratify that treaty, obviously. There's a number of situations that might appear, obviously, but it has to do, we're talking about Chilean constitutional law. As I said, treaties then are adopted in the sense that they are incorporated in the Chilean legal system without losing their international character. So we have to consider those situations. But as to the constitutionality of the treaty, the power is in the Constitutional Court, in the controls ex ante and ex post. But the termination of treaty is in the hands of the President of the Republic. So there's a number of questions that can be posed as to the suspension or maybe the modification, but those are pretty much the rules, these scant rules that we have in the Constitution. I don't know if I am addressing your question correctly.
I can imagine burning circumstances in the political sphere there, when there is disagreement and there is maybe a clash between the president and the Congress, as I see it. And we have had it also in Italy, and Fulvio has also put the finger on a similar situation when the agreement has been entered into in simplified form by the government, even in areas according to Article 8 of the Italian Constitution would require prior approval by the Parliament, and the interpretation to which Fulvio came down is that a succession of cases of acquiescence by the constitutional organs, including the number of statements by the Constitutional Court, have developed a constitutional customary rule contra legem, which makes sense until the same practice will repeat itself. But I can imagine at some point a constitutional crisis and a tension between Parliament, at least potentially, in which a highly politically relevant treaty, which has been entered into by signature by the Minister for Foreign Affairs, Prime Minister, President, against the parliamentary consent, may give rise to major issues, and the actual interpretation and application of Article 46 at the international level, suppose government changes, will will play a major role, and then Article 45 of the Vienna Convention will play a role. And here I see a parallel between acquiescence for purposes of domestic constitutional law and acquiescence for purposes of international law under Article 45. So there is perfect convergence there. When the domestic rules on the conclusion of treaties have been manifestly infringed, but such infringement is acquiesced in by the constitutional organs, and that validates the treaty both under domestic law and international law under Article 45. But when there is no such acquiescence, I think that the interpretation and application of Article 46 for purposes of the validity of the treaty under international law may become an issue. But big issues justify the job of international lawyers. But an issue may arise still at some point.
Yes, absolutely. Absolutely. Yes, you're right. In our constitutional system, there has been sometimes a tension between the power and the role of the Congress and the power of the president in international economic law, and then you have questions regarding the possibility to adopt or to participate or conclude international agreements in areas that are not covered by laws in Chile. And there was a doubt if they fell into the powers of the regulatory powers of the government and so on. So there have been tensions in Chile as well. But you have a very broad imagination in Italy, I see. Professor Palombino would like to say something.
Yes, explain.
Yeah, thank you very much. Thank you very much, Attila. Yes, of course. I mean, there should be tensions between the parliament and the government, and we know that because what happened with regard to the protocol Italia-Albania concerning the cooperation between the two states in the management of migration flows from third countries is symptomatic of this tension. At the very beginning, the treaty had been concluded in a simplified form, and at the end of the day, the parliament decided to authorize the ratification. And so, of course, that's a problem. What you said concerning the acquiescence, I completely agree with you. Of course, you put the finger exactly on one of the problems, and you are right. So I think when the act consists of a treaty that is in clear conflict with relevant constitutional norms regarding the competence to conclude agreements, the domestic and the international dimension of acquiescence overlap. That's right. The non-contestation by the involved constitutional bodies, in my opinion, can rectify, let's say, the treaty domestically and correspondingly prevent its validity from being challenged internationally. And last but not least, of course, I didn't speak, I didn't deal with the constitutional remedies because of time constraints, but of course, we also have a series of remedies in Italy, and in a case of tension between the parliament and the government, we have, of course, the instrument represented by the conflict of attribution between state powers. And that's something which happened just one time in the past, but without any kind of, any kind of significant result, just because there was a problem of competence. So who raised the conflict of competence was not enabled to do so. But as a matter of principle, this remedy exists. even though, as I said, we are talking about 70 years old practice, which is very consistent and which goes, at least from my point of view, in a certain direction. So at the end of the day, I think that a constitutional change would also be a possibility, because the fact that Article 80 of the Constitution speaks of all possible treaties with vague formula like treaties of a political nature, this poses a problem. I was impressed by the presentation of Sebastián. I think it's really very appropriate, for example, to establish a different majority as regards the approval by the Congress, depending on the kind of matter to be dealt with. In Italy, we just have one provision which covers everything, which has never been respected by the government. And that's also the reason why over the years there has been some attempts to modify, to ask for a change of the constitution under this point of view. But as we know, that's always something very difficult in Italy, if not impossible. And so, thank you very much. Thank you very much again.
Thank you.
Thank you very much. We move to the next session, or the next segment. It is the status of treaties according to the domestic legal systems of Chile and Italy. First, we have Professor Ximena Fuentes, current ambassador, and then we'll have Professor Riccardo Pavoni. And I would like to invite Ximena Fuentes to take the floor.
Thank you very much, Maria Teresa.
Slides.
Thank you very much, Professor Tanzi, and thank you very much for all the people that are present today. I see that we have a good audience in number, and also that will prompt, I think, a very good debate at the end of the panels. I have a presentation, so I hope to be successful in sharing the presentation. Yes, there. Okay. So I will speak about the status of treaties in Chilean constitutional law. And of course, this is part of the broad subject of the relationship between international law and domestic law. One previous preliminary assertion, after listening to Sebastián and to Professor Palombino, I think that it is quite clear that this topic, the relationship between domestic and international law, is not only a question of norms and legal interpretation, but behind the questions of interpretation, normally we have also political tensions. As we see, political tensions between the powers of Congress and the powers of the executive. And these tensions, these political and legal tensions, can take place within the international legal system or within the domestic legal system. And I think that the two legal systems, they have different ways of dealing with this problem. For example, in international law, it is quite clear that international norms prevail, because domestic law is not mandatory within the international legal system unless an international rule states so. Therefore, in the international legal system, the solution is that domestic law is not mandatory, and therefore states might have international responsibility on the basis of what their domestic law states. And that's why Article 27 of the Vienna Convention on the Law of Treaties states that a country, state, cannot find assistance in domestic law in order to justify the violation of its obligations under international law. But within the domestic legal system, the tension between, or the eventual tension between domestic norms and international norms finds different solutions in different constitutional systems and in different legal systems. For example, if we take the UK, now that I am the ambassador here in the UK, the political system in the UK states that treaties are not part of the domestic legal system because that is a way of protecting the system of parliamentary sovereignty. Therefore, international legal norms have to become domestic law in order to have an existence within the domestic legal system. That is what happened, for example, with the European Convention on Human Rights, which was not incorporated into the legislation of the United Kingdom until 1998, when the Human Rights Act was passed. In the United States, for example, there is also a tension here. The Constitution states that treaties are the law of the land. That provision was included in order to be clear that all states that composed a country called the United States are bound by the treaties negotiated by the executive. However, the case law, the constitutional case law in the US has stated that treaties, they have the same rank as a statute, a legal norm, which means that they cannot modify, for example, the Constitution. And it also implies that a later statute might modify the treaty within the US legal system. So as you see here, there is no a single position taken by the political systems around the world. Within the domestic legal system, conflicts of norms between treaties and domestic norms, well, might be resolved by having resort to different principles. For example, the hierarchy rule, the lex posteriori rule, or the lex specialis rule. Now, in Chile, as already Sebastián has explained, this question about the relationship between domestic and international law is regulated in the Constitution. And the Constitution has suffered some amendments in order to answer to certain questions that have come to the forefront in the relationship between Congress and the executive with regard to international law, particularly with regard to treaties. For example, customary law has not been as difficult to deal with as treaties. So we have this Article 54 that explains what are the powers of Congress with regard to treaties. And Sebastián has already explained that. Now, the question would be, in a case of conflict of norms, treaty norms, and statutes or other domestic rules, the question is, does the Constitution of Chile contain an answer when we have a conflict of norms? And here we have a sort of a vacuum that means that in the end it has been the professors of international law and constitutional law that have attempted to find answers. For example, Sebastián pointed to a paragraph here that states that the provisions, which is 1, 2, 3, 4, here paragraph 4, the provisions of a treaty may only be repealed, amended, or suspended in the manner provided in the treaties themselves, or in accordance with the general rules of international law. So some scholars interpret that according to this rule, treaties have a higher rank than statutes in Chile. And to say that has a number of consequences in terms of, I mean, if you look at the political spectrum. So the consequence would be that Congress loses certain power with regard to treaties that were negotiated by the executive and that were approved by a previous Congress. Because that would mean that Congress cannot modify or repeal treaties which, under the eyes of a new Congress conformation, are no longer necessary or good for the country. So it has a tremendous political impact if I interpret this paragraph 4 in that way. Now, if we look at the Chilean history, constitutional history, we will see that different answers have been given to this question about the relationship between treaties and domestic legislation. For example, in the early 20th century, well, first, we had not many treaties, you see. Now, almost every aspect of life is regulated by a treaty. But at the beginning of the 20th century, we would say, well, there are not many treaties. And at that time, the Supreme Court of Chile, and this is an extract from the Supreme Court of Chile, it is in Spanish, but I'm sure that our Italian friends will be able to understand. So the Supreme Court stated that treaties were like statutes, like laws. And why? Well, because it was necessary, the approval of Congress in order for the executive to ratify treaties. Therefore, that meant that they were sort of similar to laws, to legislation, to statutes. As you see, this was not a very sophisticated argument, but that was the prevailing argument for many, many years, which meant that treaties ratified by the executive, negotiated and ratified by the executive, but approved by Congress, had the hierarchy, the same hierarchy as a normal statute. And that meant then that treaties were subject to the Constitution. They could not modify the Constitution. They could not go against the Constitution. Okay, here another decision in the same way. Now, what happened in the mid-20th century? I would say, in fact, what was one of the impacts of the Chilean dictatorship to the relationship between international law and domestic law? One of the impacts was precisely the question about the hierarchy of treaties within the domestic legal system. And the problem was this. During the dictatorship, human rights were violated. And, of course, Chile then was in violation of human rights treaties to which Chile was party. The question was, could those treaties be invoked before domestic tribunals in order to look for cessation of these human rights violations or reparation for these human rights violations. That was the question. And the problem was that during the dictatorship in 1978, we have to take into account that the Chilean dictatorship started in 1973 with the coup d'etat of 11 September 1973, and it lasted until 1990. But the most opprobrious crimes were committed at the beginning. And in 1978, the dictatorship enacted an amnesty law. Therefore, that was a problem for human rights lawyers to obtain justice. And the problem was that under the theory that treaties have the same hierarchy than international treaties, then the problem was that the amnesty granted new argument under which the argument could be made that the amnesty law could not modify the obligation to prosecute and prevent those crimes. For that, it was necessary to find an argument under which human rights treaties would have a hierarchy above the normal statutes. And the amnesty law was a normal statute that had the hierarchy of a law. So the first step towards this new theory or this new position principle that sovereignty resides essentially in the nation. But in 1990, when Chile recovered democracy, there was a constitutional reform subjected to plebiscite. And force. Well, as you see, Article 5 is not explicit about giving treaties a hierarchy superior to statutes. However, the interpretation of the tribunals and the interpretation of scholars stated that with this article, with these new provisions of Article 5, then it was possible to build an argument according to which human rights treaties were above in the hierarchy of norms, above statutes. In fact, one of the negotiators explains at that time, which is this politician Francisco Cumplido, former Ministry of Justice of the first democratic government after the dictatorship, he stated that at the time when the plebiscite was being negotiated, it was not possible to get an agreement from the military regime that was going to abandon power to put treaties at the same level as the constitution. But then the tribunals will have to decide, okay, we are clear that the human rights treaties are above normal statutes, but do they have a hierarchy the same as the constitution or in the middle between constitution and statutes? And that was an open question in 1990. Well, then something else happened, very interesting. After 1990, many lawsuits began before the domestic tribunals looking for justice for people that have been killed, tortured, disappeared during the dictatorship. And with regard to, particularly with the people that were murdered during the dictatorship, there was a problem with regard to find justice for those murders. And unfortunate, and it was clear that many of those murders were committed before the enactment of the amnesty law, which is 1978. So the problem was, well, the amnesty law is of 1978. The human rights treaties to which Chile is party, many of them are older than 1978. Therefore, they were ratified prior to 1978. Therefore, even if, or the problem here is that the amnesty law, if the amnesty law has the same hierarchy as human rights treaties, then the amnesty law is later in time than the human rights treaties. And therefore, I need a theory under which the human rights treaties will prevail, even if the amnesty law came later. With the problem with the people that were murdered during the dictatorship, then it was necessary to find a way to get rid of the amnesty law. And human rights lawyers found the Geneva Conventions, so they put all their eyes in the Geneva Conventions, and they read Article 131 of the Geneva Convention on Prisoners of War, which states that no high contracting party shall be allowed to absolve itself or any other contracting party of any liability incurred by itself or by another contracting party in respect of breaches referred to in the preceding articles. So they said, well, we will invoke Article 31 as prohibiting amnesties. Now, I agree that maybe the purpose of this article was not thinking about amnesties. It was thinking about another thing, but anyway, this was the argument. Therefore, the lawyers that were working for the people that were being prosecuted for murdering people during the dictatorship, they said, well, but the conventions are from 1949 and the amnesty law is 1978. Therefore, if they are in the same hierarchy, the amnesty law prevails. And then the argument came, no, the Geneva Conventions have a higher hierarchy. And I think that this was the process under which finally the tribunals accepted the theory that human rights treaties are above the normal legislation in Chile. I have explained this in order for you to see how politics and legal questions are very much embedded in this debate about the relation between treaties and domestic norms. and that in the end, constitutions, and I see here Chilean constitution and also Italian constitution, sometimes, as they are old, they didn't foresee the political debate that is behind all this debate about hierarchy and relationship between statutes and treaties. And I think that constitutions then should look more in detail about the distribution of powers contained in them, the impact of treaties on this distribution of powers, the fact that the legislative power, which is sovereign and which represents the people, at some moment in time, should not be conditioned by the exercise of a previous legislative power, and also that in domestic law today, I think it is sensible to distinguish between human rights treaties and other treaties. So with this, I finish my presentation. Thank you very much.
Well, thank you very, very much for your presentation, which is absolutely stimulating and will provoke, I'm sure, quite a debate, because the political dimension, the slant you gave to your presentation, focusing on the relationship between domestic law and international human rights treaties, is extremely stimulating and interesting, not just, but certainly especially in Latin American countries, also in the light of the case law of the Inter-American Court of Human Rights and the possibility of perhaps talking about some kind of constitutional jus cogens body of rules. But I'm sure those issues will be addressed in the final discussion. And without further ado, Professor Riccardo Pavoni, again, with many thanks for accepting to give a presentation. You have the floor, Riccardo.
Thank you, Professor Tanzi. Try to share my screen, if I may. Is this visible?
Yes, it is.
Okay, just a second.
Yes.
All right. All right. Okay, so the status of treaties in the Italian legal system. I will try to, let's say, skip some issues which have already been said here. Oh, sorry, I forgot to thank everybody for this invitation. I'm so pleased to be here, and I'm very thankful to ISIL Italy and to ISIL Chile for this invitation, and especially to Professor Tanzi and also Donato Greco, my young colleague, who was kind enough to also share some of his opinions about these issues that I'm going to address before this meeting. Okay, I'm not talking about, these are just the provisions of the Italian Constitution, so we may skip this because Professor Palombino has already dealt with this. I mean, the provisions in the Italian Constitution dealing with the allocation of powers with respect to treaty making. The specific question that I need to address is the question of the hierarchical rank of international law norms, and especially treaties in Italy. There are several innovations in the Italian legal system in recent times. Especially, we have a growing judicial practice relating to the rank of international treaties, and I would like to focus mostly on that. But first of all, for the benefit of anybody who do not know the Italian Constitution, let's just recall that especially prior to a 2001 constitutional amendment that I will address very soon, in Italy, there was no general constitutional provision dealing with the hierarchical rank of treaties in the Italian legal system. We have, of course, a provision, very important and very pretty famous, relating to customary international law and general principles of law in Article 10, first paragraph. But that provision only covers the customary international law and general principles of law. That is, I think, is well settled jurisprudence. before 2001 and still today, we had, say, some provisions in the scattered in the Constitution dealing with specific categories of treaties. And so the hierarchical rank of these specific treaties was certainly superior vis-a-vis the rank of those treaties which were not covered by these specific clauses. Let's say the two most famous of these clauses are Article 10, second paragraph, dealing with which says that the legal status of foreigners shall be regulated by law in compliance with international provisions and treaties. Of course, this provision bestows on treaties covering the legal status of foreigners, say, a quasi-constitutional rank, but it only covers the specific category of treaties. And then perhaps even more famous is Article 11, which deals with, states that Italy shall consent to limitations on sovereignty required for a world order that ensures peace and justice among nations. Italy shall promote and encourage international organizations further in such objectives. Of course, this provision does not expressly take a position on categories of treaties, on the hierarchical rank of any kind of treaties, but it has been interpreted as especially being in favor of constitutional or quasi-constitutional rank of certain treaties establishing international organizations, those organizations which pursue peace and justice among nations. But let's say that the practice related to Article 11 is essentially confined to the treaties establishing the European Union. So Article 11 is very, very important when one deals with the relationship between Italian law and European Union law. It has been, let's say, the centerpiece of all the judicial practice relating to the status of EU law in the domestic legal system. I think that this is a pity because this provision was indeed inserted in the original constitution back in 1947, and it was drafted with the United Nations Charter in mind. So I think it's a bit unfortunate that it's not been, let's say, acted upon more forcefully, more significantly by Italian judicial bodies in relation to the UN Charter and associated. As I was anticipating, let's say the turning point in the Italian judicial practice occurred in 2001, when a constitutional law, number 3, 2001, introduced an important constitutional amendment which may be taken to be a general clause or principle, as I will say later on, covering international law obligations at large, including especially treaty. We have here the provision in Italian, and then I have summarized. This is my own translation because I don't like the translation of this provision in the website of the Constitutional Court. Basically says, as far as we are concerned, that the legislative powers exercised by the state and the regions shall respect international obligations, including, of course, international treaty obligations. This is if we compare the situation, the situation predating this amendment to the significance of this amendment is that since 2001, international treaty obligations must be considered as enjoying, let's say, what the Constitutional Court will refer in 2007 as a kind of sub-constitutional rank. Let's say, which means treaties in Italy enjoy a rank which is inferior vis-a-vis the Constitution, but certainly higher than domestic status, than domestic legislation. As I said, this is a breakthrough with respect to the previous situation because the main significance, the main consequence arising from this amendment is clearly that nowadays treaties prevail also over later domestic legislation. So domestic legislation may not, even later domestic legislation may not trump treaties. The lex posterior rule is not available anymore to the domestic authorities in order to override treaty obligations. So, I mean, the scope of this amendment is potentially very broad. It's potentially very broad also because you can say that what is, let's say, striking is that what is this primacy clause now included in Article 117, first paragraph, covers international obligations as a whole, generally. So one of the main problems here has been to discuss or try to understand whether this expression, international obligation, should be in a way diluted or, let's say, circumscribed, qualified. And when it comes to, I will just focus on treaties, which is the object of my presentation. We had a further intervention by Parliament 2 years later with this law, which is called 131, 2003, which is named the La Loggia Law, which was a law implementing the 2001 constitutional amendment, and which purports to clarify the meaning of international obligation in its very first provision, Article 1. And this provision, Article 1, basically says that Article 117, first paragraph, refers to international treaties as such, without any qualification. Of course, if one wants to be faithful to the text of these provisions, the consequence would be that any and all treaties, of course, binding upon Italy, including executive or simplified agreements, are covered by the constitutional amendment. Of course, the consequence in this particular case would be far-reaching, because it would grant to this controversial category of simplified agreements, meaning agreements essentially concluded by government upon signature, a status superior to domestic legislation. Also, I also had a look at the travaux. The preparatory work for this provision are very controversial, but there is a specific element which is telling, in my opinion, is that this decision to refer to international treaties as such was deliberately made by Parliament in 2003, because the bill which was submitted by government to the Parliament the year before only envisaged treaties ratified following a law authorizing ratification and approved by Parliament pursuant to Article 80 of the Constitution, which means that, I mean, this specific element of the travaux préparatoires militates in favor of considering the broad expression of international treaties as covering every single treaty binding upon Italy, irrespective of its importance, irrespective of the subject matter addressed by the treaty, irrespective of the procedure which has been followed for its ratification. So let's go very rapidly to the let's say judicial practice, because the judicial practice has been particularly interesting, especially in recent times. Let's say something which is unanimously known in Italy. The key judgments here, let's say the leading cases here have been twin judgments by the Constitutional Court in 2007, which dealt with the European Convention on Human Rights, and which clarified once and for all that treaties, including the ECHR, have a sub-constitutional or so-called interposed rank, a rank higher than statutes but lower than the Constitution, and can thus serve as standards for constitutional review of domestic legislation, with the obvious consequences in terms of normative hierarchy. For example, treaties, including the ECHR, remain subject to the Italian Constitution as a whole, but they are always prevail over inconsistent domestic law. It's also pretty well known that the following judicial practice by the Constitutional Court has almost exclusively dealt with human rights treaties. So the question which the colleague before was addressing at the end of her presentation is whether this primacy clause should only cover human rights treaties or also extend to other classes of treaties is a problem which is very important in the Italian legal system. And the answer to this question is not univocal, cannot a clear-cut answer to this dilemma cannot be given so far. Because it's very true that this is a slide which tries to summarize the doctrinal debate in Italy, which has been a huge debate also with respect to this particular issue of the specific categories of treaties covered by the 2001 constitutional amendment, ranging from Luigi Condorelli, very famous article saying that only the ECHR and similar important treaties are covered by Article 117, through an intermediate thesis according to which Article 117 only covers treaty which the Parliament has duly authorized to ratify under Article 80, meaning that essentially Article 117 does not cover simplified agreements, or let's say, I would say, at least the idea which I have made is that the predominant doctrine nowadays in Italy is more prudent, and saying that in the absence of further guidance by the Constitutional Court, every treaty, including an executive or, let's say, simplified agreement validly stipulated by Italy, is covered by Article 117. This is the position taken, for example, by Professor Tanzi, by Professor Palmisano, by Professor Salerno, but also by a famous scholar who is passed away some years ago, Professor Conforti, already in 2001, was taking this, let's say, broad view of the scope of Article 117. Judicial practice it's very, very true that, as I told you already, the practice basically revolves around human rights treaties or similar, or human rights, let's say, treaties related to human rights. But let's not forget, and this is a precedent which is very frequently overlooked in Italian scholarship, that the first occasion following the 2007 twin judgments where the Constitutional Court granted this sub-constitutional status to a treaty under Article 117 was an environmental treaty, a pretty famous one which has now been superseded, the Kyoto Protocol to the UN Framework Convention on Climate Change. That very, very clearly some regional statutes providing for restrictions on renewable energy production were struck down by the Constitutional Court, also relying on the Kyoto Protocol on climate change. So the very first precedent following the 2001 precedent was not about a human rights treaty, but an environmental treaty. And this remains an important precedent, militating in favor of the broad view related to Article 117. But then we had other precedent covering the UN Convention on the Rights of Persons with Disabilities, of course, a key human rights treaty. And then we have other precedents covering the UN Convention on the Rights of the Child or the European Convention on the Exercise of Children's Rights. Again, of course, these are human rights treaties which fall within the treaties covered by Article 117, paragraph 1. This is an outlier. This is an anomalous decision, which does not come from the Constitutional Court, indeed. It comes from the, let's say, a penal section of the Court of Cassation, the Supreme Court, which takes the view that a key treaty, a key Council of Europe treaty on human rights, on the human rights of children, the Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse, does not constitute a yardstick of constitutional legality for inconsistent domestic legislation under Article 117. It's an outlier, it's an anomalous decision, also because this judge, I'm afraid, comes within those judges which were mentioned by Professor Tanzi in his introduction, that do not know anything about international law, because they also said, but also they do not know anything about the relevant practice of the Constitutional Court, because this court also said that the Constitutional Court had never considered a treaty different from the CHR as setting a rank higher than ordinary legislation, which is certainly not the case, as we have already seen. Then what comes next? The next step in our judicial practice are a series of cases involving another human rights treaty, let's say, concluded under the auspices of the Council of Europe, again, the European Social Charter, which was concluded in 1961 and revised in 1996. We have at least 3 cases dealing with the European Social Charter, where the Constitutional Court accepts that also this treaty comes within the treaties covered by Article 117. One of the passages which is more famous in this first provision, the 120/2018, is that the Constitutional Court seemed to accept that the European Social Charter was covered by Article 117 because of its peculiar features, per queste sue caratteristiche, because of these features, meaning that because it's a human rights treaty which complements the European Convention on Human Rights. Again, then we have another case, always 2018, involving the European Social Charter, where indeed another convention was at stake, an International Labour Organization convention concerning termination of employment, which, however, could not be relied on in that case because Italy, unfortunately, has not ratified this ILO convention. Even here, the Constitutional Court said that this treaty, this ILO convention, has a constitutional vocation, meaning that, again, it seems to accept the view that only particularly important treaties are covered by Article 117. And then again, the most recent one, the European Social Charter, is a case which very recent, a case which was decided by the Constitutional Court this very year, judgment number 7, where again the coverage of the European Social Charter is upheld by the Constitution. I will skip because time is passing very rapidly. I beg your pardon if I speak too much. I will try to summarize these 2 key Constitutional Court decisions of 2023 in, say, 5 minutes or even less if I can. But because the first one is a very recent, so a very still very much commented upon in Italian legal scholarship, and there are a lot of contributions emerging about this very recent judgments. The first case is very famous, the case about this young Italian PhD researcher, Giulio Regeni, which was tortured to death in Egypt, allegedly at the hands of some Egyptian officials. The Constitutional Court, for the first time, but unsurprisingly, stated that the UN Convention Against Torture falls within the treaties covered by Article 117. And again, and indeed, the relevant domestic legislation was also found inconsistent with the UN Convention. Much more interesting is this third judgment by the Constitutional Court of last year. I will try to summarize this as briefly as I can. Okay, what was at stake in this judgment, which was handed down by the Constitutional Court in July, 1 year ago? It's judgment number 159/2003. It was the legality of Italian legislation creating a so-called Nazi crimes reparation funds, according to which the victims of Nazi crimes had to stop pursuing enforcement proceedings against German property in Italy, and have resort to this fund financed by Italy in order to receive compensation for the crimes that they had been of which they were victims. What is most striking is that the Constitutional Court here does not deal with the problem whether this domestic legislation is inconsistent with international treaties. In this particular decision, international treaties are used to confirm, to uphold the validity of this particular legislation, the Nazi Crimes Reparation Fund. And what is most striking is that the treaties which are relied on for the purposes of upholding this legislation are two bilateral agreements concluded between Italy and Germany in 1961, so-called Bonn agreements between Italy and Germany on World War II reparations. The Constitutional Court states, without any hesitation, that these two agreements, even if they are not clearly human rights treaty, even if one of them, the Bonn Settlement Agreement, was an executive agreement, even if the Constitutional Court does not say that, we know that that was an executive agreement. These two treaties fall within the treaties covered by Article 117. This is particularly striking, and of course militates in favor of the broad view on the coverage of Article 117. As I said, these Bonn agreements was used to uphold the validity of this legislation. The court found that a reasonable balance between the constitutional principle of judicial protection of fundamental human rights and the constitutional principle of respect for international treaty obligations stemming from Article 117 was struck by this fund. The fund reconciled the judicial protection of victims of Nazi crimes and the need to respect the pertinent international agreements. Namely, in this particular case, the court quotes the wrong Bonn agreement, the 1961 Bonn compensation agreements. In conclusion, what I would like to say is that what seems to be clear when reading and rereading this judgment of 2023 is that Article 117, according to this particular judgment, is not simply a yardstick of constitutionality or inconsistent national legislation. It also gives written expression to a constitutional principle of respect for international law obligations, which the Constitutional Court treats, considers as having constitutional rank. The court says that the principle of respect for for international law obligations is of a constitutional rank. And to me, this is one of the most important holdings in this judgment, which may have, if acted upon in the following jurisprudence, wide-ranging consequences and implications in terms of interpretation of other constitutional norms and principles, in terms of the use in balancing exercises involving other equally ranking constitutional principles, and in terms of the prudence and self-restraint that the Constitutional Court should have when testing the constitutional legality of international treaties. Thank you so much.
Thank you very much, Riccardo, for your absolutely granular analysis of the hierarchy of the position of international treaties in the hierarchy of Italian domestic legislation dealing with international treaties in general, but you yourself, like Ambassador Fuentes Trujillo, ended up giving prominence to the position of international human rights treaties or human rights related treaties. Turning now to the last session, Maria Teresa, to you.
Yes,
the floor.
I would like to introduce yes, our two main speakers, Professor Paula Cortés from the University of Chile, and then we'll have Professor Lorenza Mola from the University of Torino. And the subject they will address is vertical and horizontal direct application of international law before the domestic courts of Chile and Italy. I think Paula goes first with the introduction. Well, Paula, you have the floor.
Thank you, Professor Infante. I'm gonna share my screen. Can you see it? No, now, perfect. Okay. Well, first of all, I want to thank Professor Infante for inviting me. This was something that really took me by surprise because Professor Infante invited me yesterday. So I just thought, well, but I have to prepare something for tomorrow. But sometimes you have a little luck in life. So Professor Infante told me, because of course the panel is about vertical and horizontal direct application of international law before domestic courts in Chile and Italy. So yesterday I was reading the Supreme Court judgments, and I found a judgment of yesterday. So what I will show you is something that is just right away from the Chilean judicial oven. And I think it's a very important and in Chile sometimes sensitive topic, the one that I will present. So I would really like that our colleagues from the Italy branch can then tell us their opinion on how the system works in Italy about it. Okay, let's start. First, I want to do an overview about what is the Chilean military justice system. As you can see, that Chile has a military justice system that comprehends the constitutions, the law, and regulation that estatus and regulates the jurisdiction and functioning of the military tribunals, either on peacetime or at war. So Chile has permanent courts of martial for the Army, Air Force, and Carabineros, which is our national police, the Carabinieri, and the Navy. So some rules about what the commanding officers can do. It cannot promulgate rules and policies of those rules are established by the correspondent military authority before the deployment of the forces. Nonetheless, the commanding officer has the duty and the responsibility of giving orders to the subordinates to prevent the transgression of the rules and policies. And these commanding officers are empowered, of course, to take including administrative investigations and disciplinary measures, and the criminal punishment and investigation relates on the military tribunals. Who can investigate the case of the military justice systems? The commanding officers can investigate all disciplinary administrative aspects. If there are any evidences of criminal conduct, the investigation is conducted by the military prosecutor. And referring to the prosecution, the referral is going to the Chilean military authority in charge of the forces, and who can charge the military prosecutors. There has been efforts to change the system, for example, both because this is not just something in the Chilean reality, but also in the Latin American reality. I think it's very bounded to our dictatorship commune past in Latin America. So, for example, in a specific case against Chile, in the year 2005, the Inter-American Court of Human Rights pinpointed the problematic scope of the Chilean military jurisdiction in a well-known case, maybe that you know, it's called the Palamara-Iribarne case. Humberto Palamara-Iribarne was a naval officer that was convicted by the Chilean military court because she wrote a book about military intelligence issues and then need to be guided by ethical standards. So she was, of course, convicted by a military court and then took the books and he was in prison. So the Inter-American Court condemned this conviction, citing that the naval court had a best interest in convicting Palamara-Iribarne and therefore violate the access to impartial and competent court, which is stated in Article 8 of the Inter-American Human Rights Convention. And to align the Chile's judiciary with the international law, the Inter-American Court required to set limits to the subject matter and personal jurisdiction of military courts in order to protect, of course, the civilians from this military jurisdiction. What Chile did is, in order to meet these requirements of the Inter-American Court, in the Palamara versus Iribarne decision, the Chilean Congress dictated the law 20,477 in 2010 that explicitly excludes civilians and minors from the military jurisdiction. But this reform was promises, but since 2010, the implementation of the law has not been very successful. And there has been still several cases that, which, for example, cases with national police involved that have violated human rights from the civilians and had deprived the victim of the access to the competent and impartial court and shielding members of their armed force from justice for their abuse of citizens. So this is a very recent and very sad case. On April 27, so just 2 months ago, a conscript called Franco Vargas of 19 years old, so imagine a young guy that was from Santiago, voluntarily entered to perform the military service. And he died in Putre, this is a zone at the north of Chile, after the respiratory complication during the instruction campaign. And the result of the alleged negligence and mistreatment of the part of the officers and not commissioned officers that ignored his complaints about their declining health due to the intense cold of the place. It was like -15 and they did not have adequate clothes. And this young man died, but also 50 conscripts of the same units were registered with respiratory complication, 22 of them infected with avian influenza and Escherichia coli. So the conditions they were, it was terrible. And one of the parents of the soldiers declared that his son and the force that was affected were forced to eat raw meat and drink well water, for example. This is the mother of Franco Vargas. This woman was a single mom that, of course, is typical in Chile that the people that go, because it's voluntary to go to the mandatory military instruction, once you fulfill the positions, it's not mandatory. If voluntarily people go, I mean. But normally who enroll on this function is people that it's from the poorer layers of the Chilean society, for saying something, that wants to have a better future, of course, starting at the military. So in May, of course, there has been a dispute of jurisdiction between the extraordinary vice minister, Jenny Book, that was designated to knowledge and ruling in the case that was initiated by the military prosecution office in Arica, by the dependent of the 6th military court based in Iquique in the north of Chile. So the other part, of course, was the Arica Guarantee Tribunal, that is for civilians, that wanted to continue knowing the facts described in the complaints deducted by the National Institute of Human Rights that represent the conscript, the soldiers, and the family of conscripts Franco Vargas, all those who were performing military service in the Pocoyo and Putri barracks run by military personnel of the Army of Chile belonging to the Motorized Brigade number 24 Huamachuco. So in May 24, the Arica Guarantee Tribunal decided that the proceedings will remain in the hand of the civil jurisdiction. So they reject the request of the military envoy Jenny Book that wanted to remain the investigations in the military jurisdiction. Judge Juan Araya, of course, said that the affected was not only military personnel, but also civilians, of course, like the mother of the deceased soldier. He said there is a victim who is not military and that jurisdiction does not have the robustness of the specialized care unit of the public prosecutor office to protect his guarantees. So, of course, this then was sent, this jurisdiction dispute was sent to the Chilean Supreme Court. So yesterday, on June 25, the Chilean court determined that the investigation into the death of the conscript remains in the hand of civil justice. The Supreme Court said that to settle this dispute, first of all, it must be pointed out with complete clarity that in a constitutional and democratic state of law like ours, the jurisdiction of military jurisdiction must always be exceptional character. For this reason, military criminal jurisdiction must have a scope strictly limited and aimed only at the protection of interests, special legal provisions linked to the functions of the military forces. Its rules, consequently, must always be interpreted restrictively, a legal premise that has been invariably reiterated in the last years by this court. And the important thing, and now link of what is from our interest, is that the Chilean Supreme Court relied heavily on jurisprudence of the Inter-American Court of Human Rights. So the first case that the Chilean Supreme Court relied is the case Radilla Pacheco versus Mexico, that in this case was a case of alleged forced disappearance of Mr. Radilla Pacheco in the year 1974. And so here I think I have what the citing paragraph that, of course, state this principle that in the democratic state, that the jurisdiction of military tribunals, it's reduced and almost disappear. And in the case a state preserve it, they have to use it in a minimal way and strictly necessary. And it has to be inspired and the principles and guarantees of modern criminal law. So in a democratic state of law, the jurisdiction of military justice, it has to be restrictive and exceptional, and it has to protect a special interest. So just how the Chilean court said, and link to the special functions of the military forces. So, of course, as the court said that the military justice assumed jurisdiction over a matter that must be heard by ordinary justice, the right to the natural judge, and by extension, due process, which in turn, it is closely linked to the right of access to justice and to right to equal protection of the law in the exercise of right, which they are also included in the Chilean political constitution. So, the Chilean Supreme Court also said that the exceptionality of this jurisdiction, the court rules that having constituted the principle to settle this dispute, is not possible to only resort to the legal technical standards that regulate the military jurisdiction, since this regulatory body at the time it was dictation was year 1944. So the court reads the case with the eyes of modern criminal law, of course. and the specificity of the subject is regulated inverts the reasoning, assuming that military jurisdiction is the general rule and the ordinary jurisdiction the exception, character that consequently and thus understood assume under this perspective Article 9 on the branch code. So the court say, okay, because this, the military code that was dictated in 1944 has, of course, inverts the reasoning and make the military jurisdiction the ordinary and not the exception. So the court reads with the eyes of today. And of course, a respectful analysis of the principle of legality and division of powers. The court said, enshrined in the political constitution and of human rights recognized in international treaties that has been ratified by Chile and are in force, forces us to first term if there are exclusive and strictly military foundations that, by their direct connection with the objectives, tasks, and purpose of the armed force, that is, those that refer to the war organization of the state, make indispensable for the defensive demands of the community of a constitutional asset the need of a specific judicial channel for knowledge and eventually repression of common crimes. So again, the court relied on the power of the human rights recognized in international treaties, of course, ratified by Chile. So, of course, the Supreme Court analyzed the case with international law eyes, and of course relied, that already was commented by some of my Chilean colleagues, in Article 5 of our Constitution. So read the military code of justice with the eyes of human rights treaties, and specifically of the Treaty of the Inter-American Convention. The court also said that this court cannot ignore the facts attributed by the plaintiff as consisting of illegitimate pressures attributed to public employees exercising their function. If verified, could also be considered as constituting cruel, inhuman, or degrading illegal acts that are part of the catalog of crimes against human rights, and there's a typo in there, in accordance with international law on the matter. And then, of course, this is the article of our Constitution. If you read the second paragraph, then it's said that the sovereign is limited, but the respect of essential rights that came from the human nature, and it's the duty of the organs of the state to respect and promote those rights, guaranteed in this Constitution and in the international treaties that are ratified by Chile. The Supreme Court also relied on a second case of the International Inter-American Court of Human Rights, and this is the case Nadege Drosema versus Dominican Republic. That is a case against Dominican Republic from the excessive use of force from its military against 7 Haitian men. So the court quotes this case and said that military jurisdiction is not the jurisdiction competent to investigate and punish the perpetrators of violation of the human rights, but that the prosecution of those responsible corresponds always to the ordinary justice to avoid impunity and guarantee the right of victims to an effective remedy and judicial prosecution. So consequently, it's not admissible to maintain that the facts that are the subject of the investigation fall under the jurisdiction of military justice, since the nature legal status of those exclude them from being known by said jurisdiction, its knowledge and judgments corresponding to the natural judge, which is that of the ordinary justice. The Supreme Court ruled that it's not admissible to maintain that the facts that are the subject of the investigation fall under the jurisdiction of the military justice, since the nature legal status of those excludes them from being known by said jurisdiction, its knowledge and judgment corresponding to the natural judge, which is that of the ordinary justice. So in consequence, the Supreme Court declared that the Arica Guarantee Tribunal is competent to rule on this case and not the military justice. So why is this case important? Not only because, as we are saying, we are talking about the the vertical and horizontal direct application of international law before the Chilean domestic court. So here, of course, the court established and reaffirmed not only in the domestic, but on the international law, the principle of the exceptionality of the military justice. And it's also important because recently in May, the Chilean Congress rejected the return of military justice in cases which uniformed officers commit crimes while carrying out public order duties. And it was, if you see the votes, was just one vote of difference, 72 against 21. So if you see, I think this case is so important because show us that this is not probably something just, well, we can discuss this, what was Professora Fuentes was telling about these two parallel things, domestic and international law, you know. But I have the conviction that if, for example, a similar proposal like this go far or pass the Congress, I think we will have to, and of course, now that we are in election year, even some candidates have talked about the to return to the death penalty, for example. So I think for the international commitments that Chile has, it's very problematic. What would happen in a case if some legislation on that matter could be approved? So I think this judgment, it's very important, especially in this particular moment. So I would, of course, also like to know what are the thoughts from our colleagues from the Italian branch. So thank you for the invitation. And of course, I just give the floor to my Italian colleague. Thank you very much.
Thank you. Thank you, Professor. Now it's the turn of Mrs. or Professor Lorenza Mola, and the floor is yours, Lorenza.
Thank you. Thank you indeed. And I'd like to thank the President of ILA Italy and the President of ILA Chile for this invitation. I now share my screen. Okay, and launch the presentation. So I will give some highlights on the direct application of international law by Italian courts, having in mind a remark which was made in a recent publication by Professor Baratta, according to which international legal provisions that somehow address the sphere of human beings or individuals of enterprises do have a natural vocation, in his words, to be applied within a domestic legal system. And indeed, I will mostly focus on the case law concerning human rights treaties and international conventions on uniform private law. And I'm asking myself, how much do Italian judges have the same remark in mind, in their mind? I will touch upon three main points, namely the scheme which is used in the Italian legal system to arrange the issue of direct applicability or direct application of international law. Second, the issue of horizontal application of international conventions in particular. And third, the impact of EU law on the Italian practice. So coming to my first point, as concerns the scheme, the general arrangement for direct application of international law by Italian courts, well, the scheme has to take and takes into consideration the dualist perspective, which is adopted in the Italian legal order. So there are three conditions envisaged for direct application of international law. First, that the international norm is transformed into a domestically sourced norm, then that the international provision is self-executing, and third, to be applied instead of domestic law, that it is given a higher ranking than the law that must be disapplied. So against this scheme, we notice a tension or misalignment between scholarship and jurisprudence, because scholars tend to argue that once these three conditions are met, non-direct application of international law is an exception, while in the jurisprudence, we rather find different tendency. So I will now point to some controversial decisions denying direct effect, starting from a quite recent one by Corte di Cassazione Penale, so the Italian Supreme Court, on the European Convention of Human Rights in the Padula case. What was at stake there, in a nutshell, pursuant to a provision of the Italian Code of Criminal Procedure, the possible grounds for appeal against a judgment include the ignorance or the violation of the criminal law, or other norms which must be taken into account when criminal law applies. And there, Mr. Padula invoked Article 6 of the European Convention of Human Rights as one among these other legal norms that must be taken into consideration. However, the Italian Supreme Court denied the very possibility for an individual of invoking the violation of the European Convention of Human Rights to oppose a judgment taken in his or her regard. And this in light of the, let's say, structure of the European Convention of Human Rights. I will not go into details. I will try to come back on these points later on, because I would like to show how the understanding of the rationale of International Convention on Uniform Private Law provides for the opposite yardstick to this jurisprudence. Moreover, I would like to mention some other judgments which were controversial because they dealt with specific provisions. For example, Article 6 of the European Convention of the Adoption of Children, interpreting those provisions as offering an option to the Italian legislator of the contracting state, while commentators rather find the provisions to allow two solutions being available at the same time, so both solutions in the provision being available, being applicable in a way. And I would also like to point to the fact that the Italian judges denied direct effect to the whole provisions, to the whole conventions, in the case of the UN Convention on the Rights of Persons with Disabilities and on the European Social Charter, for example, among others. Why? Because they considered that all provisions there about the protection of the human rights of the targeted persons were programmatic in nature, vague and broad. And moreover, they found that the inclusion of a clause on implementation by the contracting parties in the convention did indeed imply that further legislation, further action was required by the convention itself. So all these lines of arguments have been criticized in Italian scholarship, and reference to this case law on UN and European human rights treaties brings me to my second point. My second point deals with horizontal application. And if the European Convention of Human Rights, the European Social Charter are not considered having direct application, apt to have direct application, so we cannot imply that there could be any horizontal direct application of these conventions in the Italian legal system by Italian judges. But we also know that there is a growing tendency in both theory and international jurisprudence to consider international human rights treaties and their norms apt to be relevant in inter-private relations. And I'm not here quoting jurisprudence from the European Court of Human Rights, but I would like to make a reference to a recent publication by Fulvio Palombino, for example, on this issue. And I would also like to point to the digest of the so-called case law of the European Committee of Social Rights, where elements of inter-private application of the conventional rules are identified by these treaty bodies. And indeed, if this is a trend as concerns international human rights law, how about the relevance of such a trend for Italian judges? Here I would like to point to the well-known decision by the Constitutional Court number 238 of 2014, according to which international law must be interpreted according to the rules of its own legal system, that is international law. And indeed, this was done by Corte di Cassazione in the decision that you can find in the PowerPoint. The Corte di Cassazione interpreted the Italian legislation on the notion of torture as implying not only a vertical dimension, but also an horizontal dimension, and this in light of Article 3 of the European Convention of Human Rights, which in turn had been interpreted as covering any act, not only in the relations between the state and the individual, but also in inter-private relations. However, a further note is that on the relevance of human rights treaty bodies for the Italian judge. And of course, we all know that if the European Court of Human Rights jurisprudence might be binding, if it is expresses a consolidated trend of interpretation, well, for Italian judges, the Constitutional Court reiterated in 2019 and in January this year that the European Social Charter's treaty body does not adopt decisions or interpretation of the Charter which are in any way binding the Italian judge. So I see here also a critical point of possible disalignment between the Italian jurisprudence and practice by Italian judges and trends that are occurring at the international level. If this is a tortuous lane to recognize horizontal application to international human rights treaty provisions, well, I, on the other way, find a highway for such a recognition in Italian jurisprudence as far as uniform private law conventions are concerned. Because in Italian case law, horizontal direct application can be found as an axiomatic result. And it is justified by Italian judges in light of the very rationale of the convention, which is to substitute a uniform law to the laws, applicable laws of countries that are parties to the convention. But we also find another argument of the conventions being lex specialis in light of their nature and in light of their subject matter. And this is notably the case for the Convention on the International Sales of Goods. I would like to point to two among many, many decisions by Italian judges of all kinds. So the lower courts, the Supreme Court, the Corte di Cassazione, on the horizontal direct application of the CISG. But I would also like to point out that this treaty is usually given autonomous interpretation by Italian courts, not by applying the rules of interpretation and the international law, but rather by using foreign judgments and the CISG principles themselves. So in any case, all this taken into consideration, I would like to raise to your attention into a further discussion a third and final point concerning the impact of EU law on the sphere where Italian judges do exercise their evaluation of the direct applicability of binding treaty law and apply such treaties directly or not. So what do I mean here? Well, I noticed that according to quite old jurisprudence of the Court of Justice of the European Union, agreements concluded by the European Union must be considered as EU law, and they are binding upon the member states. As such, in Italy, they are framed within a distinct scheme than the one that was discussed by Riccardo Pavoni. And this different scheme implies the automatic disapplication of contrasting domestic law with EU law having direct effect. At the same time, the Court of Justice of the European Union has held that its own determination of direct effects is binding upon domestic judges. So, for example, if the Italian courts in the past used to consider at least some provisions of GATT or WTO law, GATT law at the time, as having direct effect, this is not anymore possible, because nowadays there is an exclusive competence of the European Union on the subject matters covered by GATT and WTO, and the Court of Justice has found that all WTO law does not produce legal effects, except in two, let's say, small situations. And among other conventions which were denied direct effect by the Court of Justice of the European Union overall, we can find the Aarhus Convention on the information participation of the public to environmental decisions, and UNCLOS, for example, but also, as done in Italy by the Constitutional Court, the UN Convention on Disabilities. Moreover, this is very interesting because the European Court of Justice has, on the contrary, found or decided for direct effects of specific provisions in certain treaties, especially those concerning non-discrimination in the establishment, those concerning the social security, those concerning transfers of capitals, rules of origin, tariff quotas. So in these cases, when the Italian judges have to apply EU law, even though they apply they are bound to apply international treaties concluded by the EU and recognize them direct effects. What is interesting in this overall line of reasoning is the fact that since the Lisbon Treaty entered into force in 2009, all trade agreements concluded by the EU do contain a clause that explicitly excludes direct effects of all treaty provisions, and hence an Italian judge not only does not have the possibility to ever consider whether one of these provisions have a self-executing nature, it doesn't need to wait for any pronouncement by the Court of Justice of the European Union because explicit denial is already included in the convention itself. So this concludes my brief presentation, and I am eager to wait for your comments and discussion. Thank you so much for your attention indeed.
Dear Lorenza and dear Paula, this has been a very rich presentations that align very well with the second segment we have already enjoyed with the Ximena Fuentes and Riccardo Pavoni. Are there questions or comments from the audience? Manuela, please.
Thank you, Professor Infante. Thank you for both professors for their presentations. It's such an interesting topic. I was wondering if I could ask a question to Professor Cortés. Just on a side personal note, I had the pleasure of working for the Inter-American Commission on Human Rights for many years, and I was part of the litigation team that litigated Vargas Areco, Radilla Pacheco. So it's really wonderful to see how the circle comes around. But one question I have is that since this is a judgment from the Supreme Court of Chile, they cited two cases from other jurisdictions, and they did not cite the Palamara case. I find that to be very, very interesting. And I wonder if Professor Cortés has, I know the judgment is only from yesterday, but I wonder, Professor Cortés, if you have an idea of why this may be. Because, of course, you cited all the case law. This is an issue that is big in Latin America and the whole of Latin America. You cited at least 3-4 cases where the issue comes about. And I find it really interesting that the Supreme Court did not cite the Chilean case. Thank you.
Do I reply immediately?
Would you like to react immediately? Yes, Paula?
Well, thank you, Manuela, for your questions. And well, for me, I think it was a bit weird too, because it would be a good occasion to just rely on the case that Chile was a question about the military judicial system. I think it could be many reasons. One reason it could be that Palamara Iribarne case is from the year 2005, and the case quoted are from the 2010 and the 2011. And maybe a second reason could be that the Palamara Iribarne case, it was a case about the military judicial system, but more with the freedom of expression too. Because of course, Palamara went to the military judicial system and was convicted, but he wrote this book about the military intelligence and the ethical guidelines. So it was also about its freedom of expression, you know? So these two cases that I quote are much more specific about military involved in abuse of course, excessive use of force or abuse of power against civilians. So I think that that could be a reason, because if you see it's a short judgment of just 9 pages, so maybe because they are more specific. And maybe, but this is just more conspiranoic theory, the court didn't want to just touch a sensitive point, maybe, because of course the states are not sometimes very glad to know that they were involved in a case and that they were found that they violate a norm of an international treaty. So maybe the court just decided not to quote the case, and because it's an organ of the state, and maybe then it could say that even the Chilean Supreme Court said that this is happening with the military judicial system, because I think, and there's literature about it, that even with the current law we had and the system, I think it could be the case that we are already violating the Inter-American Convention with the system we already have. So I think there's a lot of doubts in there too. So that is why I would like to listen to the Italian colleagues, how it works in Italy. And so I think that was my last comment about your question. And I was thinking just a little comment about what Lorenza presented, that it was super complete and interesting. I think it's super nice that we are having this meeting, and especially when we are talking about like the different regional human rights systems, because I think you could see the difference between the doctrine of the conventional control of the Inter-American Court and what the judiciary system and in Latin America has done about it. And then, of course, you see the contrast with the margin of appreciation doctrine and how the judiciary system, in this case in Italy, of course, has that in mind when you think about the direct application of the human rights law. So that is my comment. Thank you for your question, Manuela.
Thank you, Paula. Yes. Are there other observations or comments? Andrea, please. I see your hand. Andrea Cerafolini.
Can you hear me?
We hear you very
okay.
far.
Thank you.
I
have a question to Professor Fuentes regarding the relationship between treaties and the Constitution. Are there any relevant ruling by the Chilean Constitutional Court? And if yes, if you can give us an example. If not, do you think that in the future the court could play a relevant role in this area? Thank you so much.
Thank you very much. Yes, Ximena, please go ahead.
Thank you, Maria Teresa. Thank you very much for the question, Professor Andrea. And well, in Chile today, I would say that the position of the Constitutional Court is that treaties have, in the hierarchy position, they are above the law, the normal statutes, but they are subject to the Constitution. That is the view for the generality of treaties of the Constitutional Court, which means that treaties might be the object of a constitutional action ex ante and ex post with regard to the relationship between the treaty and the Constitution. And the Constitution always prevails. Now, we also have case law before tribunals, normal civil, penal administrative tribunals. And there you might find a more broader spectrum of decisions. But I would say that in general, the other tribunals, the general jurisdiction tribunals and the penal and the civil, there is a tendency to view treaties, human rights treaties, at the same level, the same rank as the Constitution, as part of the Constitution. Therefore, in Chile, we have these sort of two views with regard to human rights treaties. And it is the view with regard to human rights treaties that has also influenced the view about the rank or the hierarchy of the generality of treaties. Now, there is another development which has to do with the direct effect of treaties. Sometimes tribunals, given the fact that I would say that now the dominant position is that treaties have a hierarchy that supersedes normal domestic legislation, some tribunals state that sometimes decide that the treaty has no direct application. Therefore, that is the way in which they just skip the problem, and they do not have to leave statutes without application because there is a treaty providing something different. So that is the situation today in Chile.
Thank you.
Yes. Are there other comments? Yes.
Maybe Maria Teresa, I can chip in and draw a parallel from a takeaway from what Fulvio Palombino and Riccardo Pavoni illustrated, which draws very much a parallel with what Ximena was just highlighting, particularly on the basis of the case law flowing from what we call them the two twin Constitutional Court decisions of 2007, because they were just rendered within the same 24 hours. In 2007, according to Riccardo's terminology, which reflects the Constitutional Court's terminology, the interposed position of international treaties. Namely, they prevail over, just like in Chile, they prevail over ordinary legislation, but they are still subject to the constitutional legal framework, which is then to be interpreted and applied by the Constitutional Court. That is to say that any international treaty is subject to the interpretation of the Constitutional Court, which provides inevitably unpredictable degree of application of international treaties. And formally speaking, I see that we have no difference between human rights treaties with respect to any other treaty. But as a matter of substance, at least as I see it, most of material constitutional rights and guarantees and fundamental freedoms that we have in our constitution, and I suppose to a large extent this would correspond to your constitution, are very much the same that you find embodied in the Inter-American Convention of Human Rights or in the European Convention of Human Rights. So the substance of the rights in question are the same. The margins of difference and unpredictability depends on who interprets them, and that is very much to do with the judicial policy on a case-by-case basis. And this brings me to at least one of the three proposals tabled by Ximena, which will not go unnoticed. Now, can we consider the possibility of placing human rights above other treaties? I mean, the trend in these times of judicial nationalism going on the rise everywhere. I mean, they started from the Russian Constitutional Court in the mid-90s, and now it has reached the UK, friends in the UK, where you are representing your country, Ximena, but also, I mean, in Italy we have had blatant examples of sovereignism, judicial sovereignism, and even this afternoon we have seen examples of what very diplomatically Lorenza called elements of disalignment. Sometimes I see outright encroachments, jurisprudential encroachments. So your question number 3, Ximena, links up with question number 2. Can we imagine a future international law development whereby international law could impinge upon the constitutional allocation of powers and then subdue the constitutional, judicial constitutional authorities in domestic legislation and make them subservient to international judicial authority? That is a wonderful dream that we may pursue, which has been pursued after the end of the Cold War, with the Venice Commission, at least in Europe, in a pan-European dimension, when the transition process in the Eastern Europe was very much under the intellectual, cultural, and financial control from Western democracies. And it seemed to be a successful process, which went on for about 10 years. But I see, unfortunately, at the intergovernmental level, very little chances for that to go. But we are, the ILA is a non-governmental organization. And we may keep on promoting and banging on this. But certainly, the human rights use Kogan's dimension, which is characterized by its matrix. Article 53 of the Vienna Convention is the imperative nature, impossibility of derogation. If as a matter of strict legal reasoning, if a state is a party to a human rights treaty and is also a party to the Vienna Convention on the law of treaties, under Article 53 of the Vienna Convention on the law of treaties, if you cannot derogate a human rights jus cogens treaty under international law, why could you derogate a human rights treaty by subsequent ordinary or even constitutional legislation? But that is a matter of logic. And as you said, we are in the middle of the field of a big tension between law and policy and politics. And we have to wait for a better international atmosphere. I mean, in the early 1990s, we international lawyers were full of hopes. The Security Council at the beginning of the 90s was functioning very well, human rights was progressing, and the rest of it. Now, these are very dark times, but I imagine our predecessors studying and talking about international law within the Institute, the International Law Association, in 1937, 1938, 1939, and 1942. Still, international law has survived, and in 1946 has encountered better chance for development than in 1937. So let's see this pendulum when it's going to touch the worst in order to go back to the better. And I will stop here. I will not make any further comments because I've taken so much.
Thank you very much. Attila, I think we have come to an end, and I would like to highlight two issues I was much attracted to that were mentioned in the last and in all of the panels. The question of direct or non-direct application of international law, and I wonder whether those conventions that were not found as directly applicable, UNCLOS, and there was another one that was mentioned, raise exactly what you were addressing, the question of the enforcement and validity of international law within the domestic fora. And the second question is what happens with other sources of other treaties that are not exactly related to human rights, for example, environmental treaties, economic treaties, question of integration treaties, the granting competences to international organizations and so on. So we still have to continue discussing these issues. So thank you very much. And I would like to say that it has been an honor to be sharing this session with you. And we will have another session in October, if I'm correct, that
Yes.
will be on issues that are very, very close to the heart of some Chilean participants, the question of food, the right to food, water, and agriculture.
Thank you very much.
And human rights.
And my honor, Maria Teresa, to share the organization and the actual realization of this. And I also wish to thank all participants from both sides of oceans and continents and geography, even though someone says that geography has ended. Well, today I saw no geography, but I know that it is there somewhere. And yes, October will be a second chance to seguir en contacto con intercambio y con mucho gusto y alegría. Muchísimas gracias y hasta la próxima.
Muchas gracias. Chao, Donato.
Chao.
Muchas gracias a todos.
Nos vemos pronto.
Muchas gracias a todos por la invitación y la participación.
Yes.
Thank you very much.
We'll leave.
Thank you very much.
Nobody wants to leave.